How to get a first class in equity. Hello, I'm Nini. I'm founder of StudyCrowd AI. I have LLB and LLM degrees from City University of London. I've got high 2-1 and first class grades in law school, and then I started StudyCrowd AI, previously known as Simple Studying, to help other law students have the same success as I did. We are now building AI-powered platform to help university students in the US and UK to get high grades and build successful careers with tutoring, career mentoring, and simple study materials. We're now also launching AI Tutor, but we have human tutoring and human mentoring services as well. The simple study materials that we have on the platform are personalized and specifically designed to help you maximize your chances of getting a first-class law degree. Why you should trust us? We have over 25,000 registered customers already on the platform for UK law, and that's like 25% of total law students in the country. 90% of our regular customers who studied law at StudyCrowd AI have reported to have got a first class after regularly studying with our study materials on the platform and getting at least 6 hours of tutoring per module. After working with thousands of law students across the country, we know exactly how to get a first class and how grading system works. So if you subscribe to StudyCrowd AI and get the premium subscription as well as tutoring services, you will most likely maximize your chances of getting high grades. So how to get a first class in equity and trusts? First of all, you should revise relevant topics. For example, 3 certainties, charitable trust, non-charitable purpose trust, and fiduciary duties. Those are the topics that will most likely come up on your exam. I suggest you do selective studying because if you revise everything that was covered on the course, you're unlikely to get a high grade, especially if you have an exam where you have a choice of questions. And you can do selective studying like this. It's highly recommended that you do so. You could just revise these topics and practice answering problem and essay questions on these topics and just focus on all your time and energy and effort on these topics rather than try to stretch yourself on all the topics that were covered on your course. Most importantly, use the IRAC structure, issue, role, application, and conclusion. What is the issue in the given scenario if it's a problem question? The role, identify all the applicable law that comes up on the problem question, and make sure that you do critical analysis here because it's very important, the critical analysis. And then finally, conclusion. In problem questions, it's really important for you to do mini conclusions after discussion of every single topic. The most important thing for you to do is to analyze every single legal issue, identify correctly, and analyze every single legal issue that comes up on the problem question. If you can successfully discuss at least 80% of the legal issues that comes up in your problem question, you're most likely going to get a first class. Obviously, it's not enough to just identify the legal issues correctly. You also have to apply the correct law and provide critical analysis that is impressive. So this is what you should do. Critical analysis. Discuss the law, then apply and analyze. Apply to the facts of the problem question and analyze what kind of outcome you would get in a case like this. Possible types of trusts. Now we're going to revise each topic that I mentioned before, one by one. And the first one is trust. There are 3 types of trust: fixed trust, discretionary trust, and charitable trust. And you should also be aware about 3 certainties: certainty of intention, certainty of subject matter, and certainty of objects. The first one, certainty of intention, what you need to discuss in a problem question like this, where 3 certainties is an issue, is there a certainty of intention? So you need to discuss whether or not this is a power, trust, or moral obligation. You should look at precatory or imperative words. If you see precatory words, it is most likely a power or a moral obligation. But if you see imperative words in the problem question, it is most likely a trust. Certainty of subject matter. Is the subject matter segregated from the bulk and clearly identified? So for certainty to be established, you need to look at the facts of the case and discuss whether or not the property in question was segregated. So for example, if the subject matter of the trust is money, is the money segregated in a separate bank account? If it's a property, is the property identified clearly? For example, if there are multiple properties in the problem that were owned by the said law, do we know exactly which property he was referring to? So this is all the issues that you need to discuss in a problem question like this. And finally, certainty of object. Who is the beneficiary? Trust fails without a human beneficiary unless it's a charitable trust, which is an exception to the beneficiary principle. So you need a human beneficiary, and there is a test that you need to apply. If it's a discretionary trust, you need to apply the is or is not test. If it's a fixed trust, you need to apply complete list of beneficiary test. Certainty of objects. Yeah, this is the one that I just mentioned, complete list of beneficiary, which is for fixed trust, and is or is not test, which is for discretionary trust. And when you apply, make sure that you cite relevant cases. Now, charitable trusts, exception to the beneficiary principle. So here you need to go a bit differently. You don't need to discuss certainty of intention, certainty of subject matter in a traditional 3 certainties problem question. So you need to do it a bit differently. First, discuss whether or not there is a charitable purpose and look at Section 3 of the Charities Act 2011. And second, is there a public benefit? By application of the relevant case law, you need to assess if, based on the facts of the case, there is a public benefit. Sufficiently large section of the community is benefiting from the trust. And finally, Cyprus doctrine. If you think that there is not enough evidence for public benefit test to be satisfied, then you can discuss if Cyprus doctrine can fix it. Cyprus allows the judge to edit the wording of the trust to make the charity work. So if the wording can be slightly amended to make it satisfy the public benefit test, then Cyprus doctrine could save the trust and could make sure that charitable trust succeeds. Another type of trust that could come up on your equity exam is purpose trust. This is a trust without a human beneficiary. As you know, according to the beneficiary principle, you need a human beneficiary for a trust to succeed. If you do not have a human beneficiary, the trust usually fails. However, the exception is charitable trust. Anomalous cases of purpose trust that have been held valid in the past include maintenance of graves, maintenance of animals, furtherance of fox hunting and religious services. And I'm also citing on the slide relevant cases where these kind of purpose trusts have been held valid. Also, fiduciary duties, you should revise this topic as well, because it is a very important topic. Fiduciary is a person of trust and confidence, and the main 2 rules you need to memorize about fiduciary duties is that when someone is a fiduciary, they cannot make a profit from their position as a fiduciary, and they cannot have any conflict of interest. Those are the 2 main rules that you need to memorize, and the case you can cite is Boardman versus Phipps. For example, discuss whether the following trusts are charitable: to ease the cultural difficulties suffered by a community addicted to jazz, and for the construction of private churches and Catholic schools. So this kind of charitable trust problem question can come up on your equity exam, and you should be prepared to answer it. So first of all, I would discuss Section 3 of the Charities Act 2011, which section of the section 3, which subsection of the section 3 is this kind of charitable trust fall under. Is it advancement of the arts, culture, heritage, or science? Most likely, yes. And secondly, discuss the public benefit test. The relevant case to cite would be Oppenheim versus Tobacco Securities and Re Compton. Trust had to be for the benefit of a class of person at large. How many people are addicted to jazz music? Probably it's not a big group. Therefore, you could potentially argue that this is not sufficiently large section of the community, and because it's a small group, the charity can fail. Construction of charities. So charitable purpose, the relevant subsection would be advancement of religion, which is section 3, subsection 1c, and the public benefit test should be applied, and the relevant case that fits on the facts of the case here is Gilmer versus Coates, where religious services were discussed and whether or not religious services like this satisfy the public benefit test. It was argued in Gilmer versus Coates that there has to be a demonstrable public benefit, and just praying is not enough because we cannot really see the public benefit. This is not limited to a private group of individuals. Gilmer versus Coates established that many religious services, such as praying and meditations, do not really have a public benefit. So most likely, on the facts of the case, the public benefit test will fail, even though advancement of religion is a recognized charitable purpose. If there is no demonstrable public benefit, like in this case, the charitable trust will most likely fail. Here are some first-class tips that you should be aware of. First of all, creative arguments. The arguments that are more straightforward will give you marks if you identify the law correctly and if you do some critical analysis. Obviously, you're going to get good marks. However, if you want like really high grades, 70 plus, you need to be more creative. You need to cite cases and make arguments that are beyond what was covered on your lecture. So the examiner sees that you've done extra reading and you've done some additional research and you understand law more than an average student. Excellent understanding of the law and impressive critical analysis is what gets you a first class. And most importantly, you need to cover both sides of the argument. You usually have two sides of the argument. So law is not math where you have one correct answer. Usually there are multiple possible outcomes. So if you can successfully identify all possible outcomes, cite the relevant case law, and make really good arguments, you will most likely get a first class. And you cannot be biased. Even if you believe in one side of the argument, you need to be neutral and make your arguments without bias. Also, correct or scholar referencing. Make sure that you don't lose easy points here. Many students lose points because they reference incorrectly. I have a very good video about scholar referencing on our YouTube channel. So if you can look it up, Common Law Simplified on YouTube, and subscribe to our YouTube channel. Or scholar referencing videos there. It's just a 15-minute video where I very easily explain how to cite correctly, and make sure you watch it and do not lose any points for incorrect referencing. Covering all the relevant legal issues that was covered on your lectures. It's very important that you cover the cases and arguments and issues that were raised on the lecture, and plus additional ones for a high grade, but you cannot omit the key cases and the essential legal issues that were covered on your lecture. Lecture is essential plus everything else, but you cannot omit any cases that was on your lecture. And finally, in-depth arguments. Sufficiently high quality sources should be cited. You should be able to differentiate what is a high quality source, what is a low quality source. and then you should cite the high quality ones. For example, journal articles, that's peer-reviewed journal articles, that's a good source to cite. Legislations, case law. If it's a problem question, you usually don't need journal articles. That makes problem questions a bit easier to answer than essay questions, because for essay questions you definitely need peer-reviewed journal articles. And from my experience, many professors always tell you, oh, you need more critical analysis and you need more research, so it's never enough. So many times I advise my students to pick problem questions if possible, because it's much easier in my opinion. First of all, because you don't need to do that much research, you just have to apply the law and just analyze the facts of the case, whereas for essay questions you need to do much further research and journal articles and all of that. Finally, if you are doing an essay question, at the end you should propose reforms. So in essay questions you usually criticize law, right? So you identify what are the problems with the law, and at the end you're supposed to also propose solutions. So okay, you identify the problems, what are the solutions? If you are a good legal mind, you should be able to propose reforms. And it's also a very important thing to do for a first class. At the end, I just want to suggest that for further information, you should go to studycrowd.ai, study using our materials, get one-to-one personalized tutoring sessions to maximize your chances of getting a first class, and attend the free revision sessions like this one, and definitely subscribe to our YouTube channel where we upload all the revision classes like this one. And you can see previous revision classes on our YouTube channel as well. Thank you so much.